Prosecutor, you have 10 minutes to give opening statement.
Thank you, Clark. Um, Your Honors, and may it please the court. We, the prosecutors, stand here today prepared to prove that defense request to exclude some evidences to be presented on the trial lacks preponderance of balance. Your Honors, we, the prosecutors, will show that the evidences in question today have been collected and maintained in lawful manner, and that all evidences, by all means, possess the gravity to be introduced in the trial. Your Honors, today's pretrial hearing is regarding the motion to exclude the evidences filed by the defense. The defendant, Elcha Parker, has been charged under Section 881.12 of the Jaltanu Criminal Code for possession of drug with intent to sell. The defendant, Elcha Parker, has been working part-time as a delivery driver for PDP, a courier company. However, she comes from a wealthy background. For the past 2 years, she has also been in a relation with Dane Carrier, who holds one prior conviction for possession of a dangerous drug. Subsequently, the company PDP, where Elta Parker works as a delivery driver, has also been under police surveillance for suspected connections to the drug trade in Jaltanu. Your Honors, the story starts on 1st March 2020. At around 10 a.m., Senior Officer Strait and Officer Fife set up a police checkpoint on the corner of Pacific Avenue because they had received reports of drugs being moved along that road. At 11 a.m., the officers directed an older model black BMW for routine police checkup in compliance with applicable law. The car was being driven by the defendant, and the co-passenger was a previous drug convict who was recognized by Officer Strait from a previous drug-related arrest and conviction. Officer Strait introduced himself to them, told them it was a routine police checkup, and asked for the defendant's identification. While checking the driver's license of Miss Parker, Officer Strait noticed some suspicious items in front of the car, including an envelope containing cash, rolling papers, clip seal baggies, and empty envelopes. The defendant appeared quite nervous. She was fidgeting and avoiding eye contact. He also noticed that defendant's eyes were bloodshot. When Officer Strait informed defendant that he would need to search defendant's car, defendant responded aggressively. Why? I have nothing to hide. Officer Strait then insisted on searching the vehicle and the defendant complied. However, he asked for an advocate, but vaguely, which the officer didn't understand. And as he was not charged with anything at that time, the officer did not clarify again instantly and moved to the search. Officer Strait and Officer Momo then searched the car and found a package that, unlike the other packages in the car, had an address but no name on it. When they opened the package, they found it contained a self-sealed bag of white powder that drug analysis later confirmed to be 750 grams of cocaine. They also found large amounts of cash in the trunk. Then the two officers immediately removed the bag of white powder from the car. Officer Fife labeled it with his initials, date, time, and location information and transported it to the trunk of the police car. Officer Strait, upon confirming the vehicle belonged to the defendant, brought a criminal charge against her for possession of drugs with intent to sell. At that time, Officer Strait, in accordance with the Jaltanu Constitution, informed the defendant that she had a right to a lawyer and a right to remain silent. Despite being informed, Your Honors, defendant voluntarily exclaimed, I don't use drugs anymore, and provided other statements. Your Honors, the first prosecution witness, Senior Officer Strait, will testify about the incidents before and during the arrest was made. After arresting Parker and detaining Carrier, the police officers transported them directly to the police station. Parker was placed in a jail cell and Carrier was let go. She was then provided an advocate in accordance with law. Within a few hours, the defense advocate arrived at the police station and asked for a private room. Officer Momo, who was present at the police station at that time, talked to the supervisor about providing a private room for Parker. But the desk supervisor informed him that no private room was available and they would have to wait for one to be free. Officer Momo informed the defendant and her advocate about it and had given them two options: either wait for a private room to be available or meet with your client immediately in jail cell in the presence of a guard. Defendant and her advocate, knowing that a guard would be present and able to hear their conversation, voluntarily chose to conduct their meeting in defendant's cell. During the interview, the defendant said to her lawyer that she knew there were drugs in the car and that she and Carrier were going to split the profits from the sale. Your Honors, the second prosecution witness, Officer Momo, shall testify about these statements before this court. Your Honors, the evidence was also brought along with Parker and Carrier into the police station. Officer Fife, who had confiscated and secured the evidence, left immediately after arriving. Before leaving, he handed over the evidence to Officer Strait to submit it in the evidence room. Around 11 p.m., Officer Strait submitted it to Mr. Avi Sutro, who is the evidence custodian at Jalton Central Police Station. Your Honors, according to Section 745.05, Clause A1, chain of custody is the ability to give an accurate accounting in a court of law as to the manner in which evidence was acquired, maintained, transported, examined, etc., by whom, when, where, and for what purpose. We will call Avistutro in the witness box regarding this matter to testify that the evidence was handed over to him in a safe and secured condition, and all required information was present on the bag. Avistutro then signed a receipt, followed standard procedures in weighing the evidence, and kept it in the evidence locker. Later, on 1st April, the evidence was transported to the laboratory for standard testing. On 5th April, results came out where it was confirmed to be 750 grams of pure cocaine. The evidence was returned to the station's evidence locker on 10th April. All at that time, the individuals who handled the evidence completed a chain of custody form that included a clear description of the evidence, the name of each person, initials, dates, times, locations, and reasons for movement, all in accordance with Section 745.05 of the Jaltani Criminal Code. Your Honors, we, the prosecutions, agree that there have been some minor irregularities, but despite those technicalities, the chain of custody form was properly maintained and it holds gravity to be moved to main trial for social policy reasons. Your Honors, I repeat, we, the prosecution, will show that the evidences in question today have been collected in lawful manner and have been well maintained. We will further show that when Miss Elta Parker was having a conversation with her lawyer, she had no reasonable expectation that her communication would be private, as there was a guard present with her own consent. Moreover, she herself waived her right to that privilege when she gave testimony about the contents of that conversation in her written statement. We will show, despite some irregularities and missing details in the chain of custody form, the evidence, 750 grams of pure cocaine, was handled properly by the arresting officers, evidence custodian, and everybody who handled it. To support our claims, we will present 2 officers and 1 official of Jaltanu Police Department as witness today. Your Honors, we understand that today the prosecution has the burden to prove, but the standard of proof is not beyond reasonable doubt. Rather, that there is a more than 50% possibility that these evidences were obtained, maintained, and handed lawfully. So, Your Honors, at the end of this trial, you will have to balance between 2 things: society's interest in prosecuting crimes related to drug trafficking and the alleged damage did to the defendant by the alleged irregularities in search and seizure following strict protocol. And I believe when the trial is over, you will see that the society's interest trumps the mere hypothetical possibilities that the defendant's right might have been violated. So, for the sake of this hearing, Your Honors, I request that you balance these 2 interests and let the prosecution use these evidences for the purpose of the main trial. That would be all, Your Honors. Thank you.
Advocate 1, are you ready to proceed with your opening statement?
Yes, Your Honor.
Okay, you may proceed.
Good morning, Your Honors. May it please the court. I stand before you today to represent my client, Ms. Eltra Parker, in a very important case regarding a citizen whose constitutional rights has been violated in the state of Zaltanu by police officers of the Zaltanu Police Force. We will see how my client was unreasonably stopped for a search, was suspected unlawfully, and was tangibly denied of her constitutional rights. The defense will establish 3 major things today. First, how my client was denied of her constitutional rights to an advocate even when she acts in plain and clear language. Second, how the officers of the Zaltanu Police Force failed to establish a chain of custody directly supporting a very well-established and important doctrine of law, the fruit of poisonous tree, and thus as prima facie failing to establish a case. Third, how there has been an extreme violation of right to confidentiality of lawyer-client privilege. Honorable judges, on March 1st, 2020, my client was on a delivery run as a delivery man for PDP with her partner Dane beside her. However, Your Honor, on her way to the third delivery of the day, her day took an unexpected turn when Senior Officer Strait, the prosecution's witness, directed her to stop at a police checkpoint on Pacific Avenue at the crossroad of Astor Road. Now, Officer Strait asked to check her identification, and then after checking her identification, without stating any reason as to why, asked if he could search her car, to which my client inquired in plain and clear language, "Do I need an advocate? If so, how do I get one now?" However, Your Honors, the officer proceeded to ignore my client's question and asked her and Dane to step out of the car. After she stepped out of her car, Eltra noticed another officer, Officer Fife, join Officer Strait in the search. Leaving Officer Fife to search Eltra's car, Officer Strait then started to interrogate my client, to which she did her best to comply with the questions she was being asked. While being interrogated, my client, as well as Officer Bent, noticed Officer Fife move the baggie containing the alleged white powder along with Eltra's black bag to the trunk of the police car, where Officer Fife spent at least 5 minutes to just put his initials on the alleged evidence. Your Honors, then my client and her partner were taken to the police station after being charged with drug possession and intent to sell. At the police station, my client again asked for an advocate. On the repeated request to consult with an advocate, she finally got a chance to speak with one, but only after having waited several hours since she was being detained, Your Honor. Your Honor, still my client was not provided with a private room to talk to her lawyer and was told that there was none available. Your Honor, you are going to hear from Ima Yenta, who is a defense witness, testify the fact that the officer who is in charge of interview rooms never checked the reservation logbook to give a private room for my client to conduct a private conversation with her lawyer. Later, it was found that there was a private room available just after 15 minutes of my client's interview began. The court is going to hear today, had they been given the information prior, Eltra and her lawyer would have waited for 15 minutes to have the private conversation. As a result, Your Honor, my client Eltra, who was already afraid about delivering the packages on time and about losing her job if she did not do so, had no other choice but to have the conversation in the interview room with a guard being present for security. The court will hear today how my client's legal provision on confidentiality of lawyer-client privilege was violated by the guard being present there for security. Therefore, prior to the collection of the evidence, transport, storage, and use of evidence has not been done in accordance to the procedure. The procedure has not been followed, Your Honor. Right to silence and lawyer-client privilege has been violated. The court, at the end of this pretrial, will observe how the officers of Zaltano Police Station violated the laws in handling the evidence. The court will learn today, through the defense witnesses, Ms. Eltra Parker, the defendant, how her rights were tangibly denied. From Officer Bent, the third officer at the alleged crime scene, how the officers failed to establish clear chain of custody, and through Ima Yenta, Zaltano Police Station office manager, how they stripped my client from exercising her lawful rights. Your Honors, the defense believes that the criminal justice system of the state of Zaltano is very protective of the rights of its citizens, and the defense is hopeful that the citizens of Zaltano will not be let down just because of some officers of Zaltano police force having gone beyond the law. Hence, at the end of this pretrial hearing, the defense respectfully requests the court to exclude all statements made by my client, Eltra Parker, at the arrest scene and in her interview with her advocate, with a guard being present, to exclude the white powder seized by the arresting officers, and to exclude the chain of custody of the seized white powder. That's all. Thank you, Your Honors.